Before the hearing begins, can I express the board's thanks to both sides for the way in which they've got the papers together for us in what has been a very short timetable. You've been operating without the benefit of legal aid, and we appreciate that too. But it's made our task very much easier in preparing, and so thank you all very much indeed. Mr. Hissell.
Lord, thank you. As your Lordship, my lady, knows, I appear, of course, for the appellant. With me, my learned friend, Mr. Birdling, and to my right, of course, my very learned friends from the New Zealand Bar, Mr. Manda and Ms. Markham. Sorry, and Mr. Davey.
Yes.
I do beg your pardon.
Thank you.
My lady, my lords, on the 20th of March 2002, the appellant was convicted after trial of the murders of his wife and daughter. His appeal against those convictions went to the New Zealand Court of Appeal on the 13th of August 2002 and was dismissed, and we are now before this board with leave granted on the 14th February 2013. If I could take the court, please, immediately to the second supplementary bundle of documents, and it is at tab 5. And the prosecution case.
Do you have a memory stick number, please?
I beg your pardon?
Do you have a memory stick number, please?
Shall I explain that in most of the papers we have a number at the bottom right-hand corner which links in with the memory stick. And it's very helpful if every time you refer to a page, you refer to that number.
Regretfully, this is one of the few upon which it doesn't have a number on mine, but we'll do our very best to deal with that.
It's in the supplementary.
It is in the. It's at tab 5 on the second supplementary bundle. And
do you know whether it is on the memory stick or not?
It ought to be.
It is. It was in the memory stick that was served by the respondents on Friday, but it appears at a separate file.
Yes, well, I've got the separate file. Well, do proceed and we'll try to locate it.
Well,
but
thank you.
The practice direction does stipulate that citations should be made to the memory stick number as well as the hard copy number.
My Lord,
now, I know that you've been under some pressure to prepare, and obviously we'll be tolerant about it, but ultimately it would be very helpful to me and to others who are dealing with the case through our computers if the memory stick number can be given at the same time as the...
My Lord, we will do our best to rectify that in the course of the morning.
We certainly had the supplemental memory stick on Friday, for which I at least was extremely grateful, yes, and which did contain, as you say, the second bundle. I'm not sure that what's currently on our machines will necessarily include that. It may just possibly be missing. I can't readily find the second bundle on it.
Well, my Lord, perhaps I can
no, that's really
address the document.
It's really said for the benefit of others rather than you. That.
Thank you, and I will see if I can address it orally without the necessity to go through to the bundle itself. I was to submit then that paragraph 4 of that document set out the facts of the prosecution case, and I know those facts are known to the board, so I won't go into any detail.
Is there anything different there from what we already get from the Court of Appeal?
My Lord, no. My Lord, no. In essence, our submission is this. There were two fundamental planks to the prosecution case. First, the staining found on the appellant's shirt was Christine Lundy's brain tissue deposited wet. That was the first and major plank to the prosecution case. The second one was that the time of death was between 7 p.m. and 7:15. There were, of course, other planks to the prosecution case. But in essence, as the learned trial judge said in summing the case up to the jury, if either of those fell, then of course, in reality, so did the case against the appellant. A summary of our grounds of appeal is set out in the document that I can't take you to, but in essence there are 4 broad grounds. Number 1, grounds relating to nature of the material found on the appellant's shirt. The second, relating to the pathological evidence regarding time of death. The third, relating to computer evidence, the computer evidence that the Crown at trial prayed in aid to support the time of death. And fourthly, the failure to adequately direct the jury regarding the identification issue. We received last Tuesday a communication from the Crown that we are extremely grateful for. This, we suggest, is a substantial development in this case, as it relates to the state of the tissue taken from the appellant's polo shirt that hitherto has not been disclosed before. A bundle of disclosure was served on us by the Crown, and we, as I say, we're grateful for them unearthing it. The bundle we have included in our appellant's supplementary bundle, tab 18, page 319. And if I could take the court to that, please.
There's number for this. It should be 318 on your... 318 on the supplementary...
My Lord, yes, and if I could take over the page to 319.
Yes, thank you.
To explain, this is a document from the officer in the case, Detective Sergeant Grantham. He is communicating with his commanding officer, a detective, in fact, Detective Inspector Brew, it seems, and he is seeking funding for the trip to the United States to visit Dr. Miller. My lords, my lady, page 320, if I can take the court to 3 paragraphs up from the bottom of the page. The Detective Sergeant Grantham, the officer in the case, is telling Detective Inspector Brew what the state of the evidence is thus far in the case. Dr. Pang, and Dr. Pang was the prosecution pathologist, Dr. Pang also suggested a neuropathologist should be able to view the slide and be able to identify the cells by morphology, in round brackets appearance. He suggested a Dr. Heng Teo. On Tuesday the 9th of January 2001, I met with Dr. Teo and he viewed the slide. He would only commit to saying the cells are tissue cells. He opined that the time lapse between the murders and the preparation of the slide, some 58 days, was too long. The cells had degenerated badly. And then further down, when he looked at the slide, he commented that he did not think he, Mark Lundy, should be convicted of murder on the strength of the cells in the slide. I did not comment about further supporting evidence. He further pointed out that just because Christine Lundy's DNA was on his shirt didn't mean a lot, as she was his wife. He later commented, etc. And then over the page, and this is Detective Grantham still, what this experience has done is give me an early insight into possible defences for any subsequent trial. More importantly, it highlighted the importance of identifying an expert who has experience in neurocytology and morphology, not as with Dr. Teo, whose experience rests on slides presently directed from the neurosurgeon or from fresh tissue that has been fixed and prepared at optimum conditions. We need an expert who has viewed material similar to our exhibit, tissue collected weeks or months after the murder. In correspondence with this court, we immediately gave notice that we might seek to amend our grounds of appeal. We've reflected on that and chosen not to, because we think that, in essence, it comes into play in any event during the course of grounds 1 and 2.
I thought it fitted rather neatly with a complaint which you make that Dr. Sinek, I hope I pronounced the name correctly, she was saying she wasn't aware that there had been this time interval. She thought it was a matter of something like 30 hours instead of over 50 days.
My Lord, yes.
So that point is already in your case,
Yes,
I think.
absolutely. But of course, it has a significant importance to the issue that was in the trial, because the issue was, the remaining issue in the trial as to the tissue was either on the prosecution case it was deposited wet, and if so, the appellant must have been present during the course of the killing, or on the other hand, the defence, their case was, of course, that it was deposited dry, and therefore deposit must have been either accidental or deliberate. That was their case. And the real issue to determine whether it was deposited wet or dry was the condition of the tissue.
Well, that was the issue at the trial, because the nature of the material was agreed. But what's your case now?
Well, the nature of it was agreed, but the actual issue in the trial was whether it was deposited dry or wet.
Yes, I understand that.
Yes, and our case is, as was the issue at trial, if the tissue had degenerated, then that was proof that it had not self-preserved in the manner in which the Crown put it, and therefore it deposited dry as opposed to wet. And that's the importance of the revelation of this document. And that was a live issue in the case. Had it been deposited wet or dry, the only means the experts could say is to determine that was, had the cells degenerated. If they had, no self-preservation must have been deposited dry. And that was the issue.
I don't know whether you're going to make anything of what we see at the bottom of page 320. This is where the comment is made that he didn't think that Mr. Lundy should be convicted of murder on the strength of the cells on the slide. That, of course, is looking only at one item of evidence, and he doesn't...
My Lord,
mention...
I don't place any weight on that particular passage.
Yes.
The point made by the officer, of course, is a good one. But the fact remains that the burning issue in the trial was wet or dry, and the only means of determining that was the state of the tissues. And the Crown's case very firmly was always that well preserved, no degeneration.
Yeah.
And of course, there was the disclosure that the neuropathologist put little value on the finding of Christine Lundy's DNA on the shirt because she was his wife, and we'll address that further in the appeal later. When
Amber's DNA was too.
Yes, it was.
That's another factor one has to keep in mind, along with other things.
Absolutely. But of course, the evidence from the pathologists in the case is that it is not uncommon in a family setting for either mother or daughter's DNA to be on father's shirt. And I'll expand on that in due course. It's apparent from the memorandum, of course, that Detective Sergeant Grantham was very alive to the potential value of this information for the defence. And he, of course, chose not to disclose it. My Lords, insofar as that is concerned, if I can take the court to volume 5, please, of our bundles. And this is tab 24, and it is page 2354. To explain, this is a document sent by the registrar of this court to trial counsel, former trial counsel, yes. Now Judge Berens, Queen's Counsel. And this is a letter, it's a response to the request from the registrar of trial counsel. And addressing ground 2, our petition relates to disclosure in respect to the expert shopping on the part of the prosecution in respect to the identification of the shirt staining. Did trial counsel or his instructing solicitors seek disclosure of and material in relation to this, either prior to or during the course of the trial? The answer came back, I know that the general disclosure request was made. I do not recall a specific request for the results of expert shopping. I was not aware that this was happening or had happened. I proceeded into trial on the basis that everything relevant had been disclosed. So trial counsel didn't know.
At the material time, was it the rule that there was an obligation on the Crown to disclose material, unused material, which had the potential to be beneficial to the defence case?
My Lord, yes. And of course we've included in our bundle for the board's assistance at volume 3, tab 40, the case, of course, well-known case of Judith Ward, yes. Which set out the common law position. Requirement. And of course the common law position was applied in New Zealand.
So this is part of the failure to disclose ground.
Yes, it is.
And the bit that you say that hasn't been disclosed is Dr. Teo's opinion, what? That the cells had degenerated badly?
Yes. And his views on the DNA.
Well, you don't need Dr. Teo to... Do you really need Dr. Teo to justify the proposition that people in the same household may get their DNA on each other's clothes?
No, the primary point, of course, is his
anyway, those are the two things you want.
Advice on the state of the tissue shell.
Yes. So it's the degeneration.
Yes.
And the state and the secondary transfer of DNA.
Yes. A further point would be, of course, and it's a live point in this appeal, that certainly it was the case that the Crown's pathologists, Temple Camp and Pang, saw the necessity for a neuropathologist, because, of course, that's something they now refute. Our case is that a neuropathologist is the expert you go to, re-identification of brain tissue. And of course, this revelation is contrary to the respondent's case, that's a nonsense. Because here we have the prosecution's pathologists saying, you need to go to a neuropathologist.
But it isn't. But what they got wasn't a neuropathologist. Dr. Miller isn't a neuropathologist,
No.
is he?
No,
He's an immunochemist.
no. Well, that is another live issue.
Yes.
His expertise is unknown as to brain tissue. All he opines is, I know what brain tissue looks like. There's a far cry from that and the expertise of a neuropathologist.
I'm not sure he says that he knows what it looks like. He says he knows how it reacts to antibodies.
Yes.
Which is different.
Milor's right.
What
In
about
fact,
the reference at the top of page 321? I mean, we're given experience in two different aspects of this art. Do you see that 321? The second paragraph highlighted the importance of identifying an expert who has experience in neurocytology and morphology.
yes.
Now, does Dr. Miller fit that classification?
Yes. Well, not at all.
Not at all.
Not at all. Not at all. He is not a neurocytologist. He's if anything, a cytologist. And as he confessed at trial, he certainly wasn't someone who was a specialist in matters of the biology of the brain.
So what we have here, if I've got it right, Mr. Hislop, is the officer reporting, one, our pathologists are pretty sure this is brain tissue.
Yes.
Glial cells.
Yes.
But they say we should refer to a neuropathologist who can give a further opinion based on appearance.
Yes.
Dr. Teo is such. When he's seen, he says, can't tell they're degenerated.
Yes.
And then, therefore, the further alternative that's being canvassed is Dr. Miller's expertise, which is in immunochemistry.
Yes.
Thank you.
Just to pick up the detective constable, detective sergeant, his report says that Dr. Teo suggested a neuropathologist who would be able to view the slide and to identify the cells by morphology, and he recommended Dr. Teo. That's Dr. Pang again.
Yes.
But then on page 321, the detective officer says, this has highlighted the importance of identifying an expert who has experience in neurocytology and morphology, not as with Dr. Teo, whose experience rests on slides presented directly from the neurosurgeon. Well, is he casting doubt on Dr. Teo's ability to interpret from a morphology perspective?
It appears, quite frankly, what he's doing is not liking the answer that he got.
Well, is he not casting some doubt? Because I think the point being made in the second paragraph on page 321 is that there's a difference between fresh tissue,
Yes.
which has been fixed and prepared at optimum conditions, which would be within his expertise.
Yes.
But here we're dealing with a material which is similar to our own, which is collected weeks or months later.
Yes.
And that's a different problem, certainly an aggravated problem, which requires special expertise. So it's being said, as I understand it.
That is one construction.
Well, that's what he seems to think.
He seems to think
that
yes.
that what's needed is somebody who's used to looking at things that have been around a bit, rather than fresh samples
Yes.
straight from the
Yes.
bedside to the laboratory. He doesn't show any sign in this memorandum, perhaps unsurprisingly, at least unless it's further on down, of understanding the particular science which was eventually used.
No, that's right.
That's right, isn't
That's right.
He deals with it on page 319, the fourth paragraph from the foot of the page, that he's been introduced by a local pathologist to Dr. Miller, who specialised in lifting smears from slides and then conducting morphological and chemical examinations. It's
Yes.
no more precise than that.
Yes.
But it is quite striking here that we have the revelation, which wasn't made known to counsel at the trial, that this material was not fresh.
Yes.
And that would have provided, at the very least, a basis for cross-examination, which wasn't available.
At the very least, we would say that it would have informed his decisions, trial decisions, and it would have informed him when going to his own experts, and it would have informed them. And the difficulty in the cases, as we can see, Dr. Sinek, for instance, being an example, she wasn't so informed. And of course...
I'd like just to go back to this second paragraph on page 321. The premise on which the statements contained in that paragraph have been made, the premise presumably is that notwithstanding the vintage of the slides, there are experts who, unlike Dr. Teal, can bring to bear an examination based on morphology that will reliably provide the answer. Is that a valid premise?
No, very much not. And part of the fresh evidence that we will be, in due course, inviting the board to accept is that it's for that very reason it's not possible. And to put that in the round, if I may, insofar as the IHC procedures are concerned, the point is that because the cells had degenerated and there were no controls within the IHC procedures to meet that degeneration, the reliability of the methodology adopted by Dr. Miller was flawed.
This is your combination of Professor Sherd, Whitwell, Gatter and Swires, is it? I mean, they're saying,
My Lord, yes.
Given the delay, I think you're saying in paragraph 77 of your case that the materiality of, it's really, the point is, it's impossible, they say,
Yes.
By any skill to determine the nature of the substance.
Yes. My Lord, yes.
But Dr. Miller didn't rely on appearance, did he? He positively disclaimed relying on appearance.
But what he disclaimed also was he was dealing with degenerated cells.
I understand that. I've got that.
And what he didn't do, and concedes he didn't do, is have a control available to cater for degenerated cells, because of course he said, no, this had self-preserved.
Yes. Now, I've got the degeneration
Yes,
point, Mr.
yes,
Tom, but
thank you.
it isn't appearance, that's
No,
what I'm after.
Yes. Yeah. So that we submit is the new revelation and the importance of it. And if we can then move on, please, to paragraph 48 of our case document, please, case for the appellant. And I suspect, my Lord, that it's, as it's not page numbered, it's not going to make the...
Don't worry, I can get it if it's paragraph 48 of your case.
My Lord, thank you. Therein the first ground is stated, and we simply emphasise in that paragraph the importance of the brain tissue evidence in this case, and I don't think we need to go further. And of course, we have already addressed this morning the importance of the state of the cells as to that argument. In advancing the grounds under our first two broad headings set out in the petition, we of course will be inviting the court to give us leave to adduce the fresh evidence. And it's to those principles I turn, if I may, briefly. And if we can go back in our appellant's case, we addressed them at paragraph 41 in the first instance. We there refer to the case of the Queen in crime. The jurisdiction to allow an appeal is set out in that passage, and I doubt whether there is any dispute in this court on that. Over the page, in general, the evidence must be new or fresh in the sense that it was not available at the trial and be relevantly credible and of a nature, if given with the other evidence adduced, might reasonably have led the jury to return a different verdict. Of course, that passage was specifically approved by the Court of Appeal in Bain, and of course this court in Bain accepted those principles as set out in the Court of Appeal by Mr. Justice Tipping, and we set those out at paragraph 22. Of course, Bain, since those principles in Bain since have been accepted in the Supreme Court of Noble and also in the Supreme Court of Fairburn that I know your ladyship presided over. So there is no issue insofar as that is concerned, but it might be helpful looking at paragraph 22 of Bain, and might I take the court to volume 1, please, tab 6.
Did you say volume 1, tab 6?
My Lord, yes.
It's the authorities, volume 1.
Oh, my Lord, I'm sorry. It's a bundle of authorities volumes. We have 3 volumes in all, and this is volume 1 of 3. We have an electronic...
3003.
My Lord's ahead of us. Now, looking at paragraph 2, please, if I may, an appellant who wishes the court to consider the evidence not called at trial must demonstrate the new evidence is A, sufficiently fresh, and B, sufficiently credible. Ordinarily, if the...
I'm sorry, where are you reading from, please?
Sorry? Yes, 22.
22. Sorry, I thought you said 2.
You did say it.
I apologise. I'm sorry. An appellant who wishes the court to consider the evidence not called at trial must demonstrate that the new evidence is A, sufficiently fresh, and B, sufficiently credible. Ordinarily, if the evidence could, with reasonable diligence, have been called at trial, it will not qualify as sufficiently fresh. And we emphasise the following: this is not an immutable rule, because of the overriding criterion is always what course will best serve the interests of justice. And then further down, on the other hand, the court cannot overlook the fact that sometimes, for whatever reason, significant evidence is not called when it might have been. The stronger the further evidence is from the appellant's point of view, and thus the greater the risk of a miscarriage of justice if it is not admitted, the more the court may be inclined to accept that it is sufficiently fresh or not insist on that criterion being fulfilled. And of course, over the page at paragraph 26, and I won't read it. The three streams, as it were, are summarised. Leaving Bain and...
Just before you do,
Yes.
what's set out there is, as you say, a threefold test for admission of fresh evidence.
My Lord, yes.
The questions of freshness, credibility and
Cogence.
impact.
Yes.
But is the third at all affected by the subsequent decision in Matenga?
It is, and when we come to the proviso, I'll deal with that if I may.
Right. And the other question is just this, it's a question of practice. Does the court in New Zealand sometimes hear the evidence de bene esse with a view to deciding whether to admit it or not, or does it make a principled decision whether to admit it and then either hear it or simply take it on paper, or what is its practice?
Can I take the court perhaps to Martinga?
Do it in your own time.
No, I can look up Martinga now.
Yeah. Yeah, please.
Just Thanks. Bundle 2, tab 28.
Yeah.
Yeah, electronic 3467. And if I can deal with over the page at 3468.
David hasn't got a bundle of these. Sorry, which tab again, please?
My Lord, I apologise.
No, you don't need for you to apologise.
No, it is tab 28.
Tab 28, thank you very much indeed.
And can I take the court to 3468 at the bottom? It's part of the head note, but it's helpful on this point. And I go to line 5, if I may. And perhaps I should start a little earlier up the page. In order to come to the view that the verdict of guilty was inevitable, the court had itself to feel sure of the guilt of the accused. Before applying the proviso, the court had also to be satisfied that the trial had been fair and thus that there had been no breach of the right guaranteed to the accused by Section 25A of the New Zealand Bill of Rights Act 1990. In coming to its conclusion concerning the inevitability of the verdict, the appeal court had to take full account of the disadvantage it might have in making an assessment of the honesty and reliability of witnesses on the sole basis of the transcript of the oral evidence. In a case turning on such an assessment, the court would often be unable to feel sure of the appellant's guilt and would therefore be unable to apply the proviso. The fact that the jury had returned a verdict guilty was not to be taken into account.
Well, the answer to my Lord's question then, it depends.
Yes.
Yeah.
Well, yes, but forgive me, Mr. Hislop, you're obviously right about that, and everything that's said there is right. But Matenga represents, unless I've misunderstood it, a definite shift.
My Lord, absolutely.
From a jury impact test,
Yes.
pure and simple,
Yes.
to a recognition that the ultimate responsibility for deciding whether a conviction is safe or not rests with the Court of Appeal.
Yes.
It's a shift from
Absolutely.
the previous New Zealand practice to Vice, which is the Australian case.
Yes, quite.
And that, as it happens, accords more or less with the English understanding of it. See Pendleton, Burridge, Dial,
Yes.
and a large number of
Yes.
other cases. Now, all that I was asking was, given that, and given that Bain was before that,
Yes.
do we need to read into Bain the qualification of Matenga, or don't we?
In short, I think the answer must be yes.
Right. Thank you. And the other question was a question of practice, which please come to at any stage. You needn't answer it now.
Yes.
But I'm conscious that I'm at least encumbered by the knowledge that at least in England and Wales, where this kind of problem arises of,
Yes.
let's just call it additional scientific evidence for the moment to avoid prejudging the question of whether it's admissible or not.
Yes.
One of the strategies which is available to an English court is to hear it de bene esse, or to give the opportunity to some of it to be heard de bene esse before a decision about admissibility is made. Now that, some might say, is a rather pragmatic fudge. I don't know whether it's a practice which is adopted in New Zealand or not, and at some stage, if you could tell me.
I will get the answer. I know more about the English practice than the New Zealand one, I'm afraid.
Right.
Perhaps I should add that as far as the board is concerned, it isn't our practice to hear evidence. I mean, we regularly accept written material such as reports de bene esse.
Yes.
But if there's a question of the evidence having to be tested, it would have to go back to the Court of Appeal.
Yes.
For the Court of Appeal to hear the evidence.
Yes, as I understand it, that is the board's practice.
Yeah.
Yes.
Okay.
Yes.
You don't seek any different result in this case?
No.
No.
No, not in the facts of this case.
Yes.
And we will deal with those, why that is. But we would put, in fact, ourselves in the same position as in Bain, where it wasn't thought that Martinga would have made a difference. Sorry, Barlow, I mean.
Barlow, yes.
I say Bain, Barlow
Yes.
is in fact. And we would put ourselves in that position, but we'll address that in due course when the need arises.
But because in Barlow it was held that the evidence was overwhelming.
Yes.
Yes.
Yes, that is the point. Paragraph 44, please, of our case. We simply make the point that the overriding test is what is in the interests of justice as a matter of New Zealand law. And we submit that the fresh evidence, where the fresh evidence relates to expert forensic evidence, the freshness criterion is not strictly applied, and the focus is instead on the cogency of what's admitted. And we there refer to the case of Wallace, and we set out therein, and I won't take the court to that authority, but we set out the passage upon which we seek to rely in that case, and right at the foot of the page, the part of the passage that we rely on and lay some emphasis is the present point is that on a bad science argument, the door can never be closed, even if the better science is not fresh in the conventional sense.
Now, is that your emphasis or theirs?
Yes, ours.
Yours. The emphasis that was in the original is actually on the word could after bad science 4 lines up, isn't it?
Yes.
I'm sorry, was that an indication that this is not reproduced correctly, that there should be emphasis?
No, what has happened, my lady, is in fact on the reproduction. We have in our paragraph 44 stated in round brackets, emphasis added, internal citations omitted. So we don't seek to mislead anyone by that. That we simply have emboldened that part of it to lay emphasis to the proposition that we're praying in aid. Thank you.
Can you just explain what you understand by freshness? Because the Crown's case against you on this chapter, as I understand it, is that this evidence doesn't satisfy the test. It's not fresh evidence. So how is one to determine whether it is or isn't?
It's fresh in the sense that it wasn't called at trial.
But that's not good enough. That's not good enough.
And of course, it might have been uncovered given diligent research.
The test, as I understand it, is you ask yourself, was it available? And yes. Was it reasonably available in the sense that it could be produced at the trial? The science was there, it was known, the people who could produce the oral evidence about it were available, and therefore the argument is, well, in that case, what you're tendering now is not fresh because it could have been done at the trial.
And what we suggest in this case is there are exceptions to that rule, and two of them to which we address.
But the starting point is that you accept that this is not fresh evidence, as that term is used.
Yes.
Yes.
Yes. Right. And we say we fall into some exceptions, well-known exceptions, to that principle. And perhaps before
Are you content to abide by the categorical statement in Bain about the three-pronged steps, or do you argue that the test is miscarriage of justice and freshness is an aspect of that assessment?
Absolutely. What we say is the interests of justice test, in fact, subsumes the freshness because it cannot be as a matter of logic when one thinks about it. If we have flawed evidence for whatever reason in the trial, and this court is convinced that something's gone wrong and it's in the interests of justice that this should be accepted, it cannot be that issues as to finality and freshness would stand in the way of doing justice.
Now, is that a proposition that relates specifically to forensic or scientific evidence, or does it go right across the board?
No, my submission is it must, as a matter of logic, go across the board. But it might be that it's more pertinent in the field of science because of the difficulties of advancing science. We know that science in some quarters moves very quickly, and what was thought to be scientifically accurate in one era by the next era might be proved absolutely wrong.
But this isn't a case of developing science.
No, it's not. No. It's not. We say in this case there are exceptions, and those exceptions are firstly, and we set them out in fact at our in the case of at our paragraph 45, we refer to the case of Oliver. It was held in that case in the interests of justice to admit fresh evidence, notwithstanding it could conceivably have been uncovered and led at trial. And the particular passage we refer to, which we include in our case note, is paragraph 48. The evidence could have been called at trial, and we accept that it would have been called had Ms. Croft known of it, Ms. Croft being trial counsel. That it was not called as attributable to Ms. Croft's belief following diligent inquiry that no useful challenge could be made to the Crown's medical evidence, It is not a case of a trial tactic that counsel now regrets, nor of insufficient diligence and preparation. Something has nonetheless gone wrong in the sense that relevant evidence was not led on an issue that went to the heart of the defence case. And that, of course, is one exception. The second exception...
Is it really, I wonder if it's really an exception. Bain, in the passage you quoted earlier, in paragraph 43, speaks of the test of freshness as being a question ordinarily of whether the evidence could, with reasonable diligence, have been called at the trial.
Yes.
So it might well have been available, but if reasonable diligence was used and the evidence was nonetheless not led, it would seem to be fresh within the meaning of Bain.
Well, going back to Bain, if I may. It certainly seems that, and it's accepted in Oliver, that in essence, if, for instance, trial counsel's expert had misled, for instance, trial counsel, and that was the reason. So trial counsel's been diligent, made the inquiry, found the expert, and the expert's got it wrong. And then, of course, we say that would provide an exception on the authority of Oliver to the strict requirement of freshness.
So you say in this case, never mind, in a sense it may not matter whether it's accommodated by the definition of freshness or by an excuse for lack of freshness. You say that in this case, as I understand it, the defendant was advised by a very experienced forensic pathologist, Professor Venezis, that there was no reason to doubt the conclusions that Dr. Miller had arrived at. Yes. And the case proceeded on that basis.
Yes.
And either that's a sufficient reason or it isn't.
Yes. My Lord, yes.
Right.
Yes.
In a way, it's a slightly added debate as to whether it qualifies as fresh, whatever that means. I mean, ultimately, our position is such is the quality of this evidence that its impact on the safety of the conviction it cannot be overlooked, and whether it qualifies as fresh or not is really beside the point.
My Lord, yes, that's the point. And of course, that's why in paragraph 22 of Bain, the passage goes on, having addressed freshness of evidence, this is not an immutable rule because of the overriding criterion is always what course will best serve the interests of justice.
Yes.
And we emphasise that, of course.
Well, there we are. That's the test you invite us to apply.
Yes, yes. We, of course, at paragraph 26, go on to address Cassidy and Campbell, which is a variation, as it were, on the same theme. At 47, we address Fairburn, which deals with trial counsel error.
Yeah, but I mean, there are other exceptions. There are other cases as well, aren't there? I mean, the classic case is the man who's mentally ill, and his mental illness directs him to prevent his team from running diminished responsibility.
Absolutely, my Lord. That's what. Absolutely, absolutely. Now, if I may. Just before leaving the tests, the respondent in their written case puts these important qualifications that we say apply in this case in relation to freshness. They suggest that those qualifications are in effect trumped by issues of finality of trial. We respectfully submit that that is not so and could never be so. We don't suggest it's a free-for-all, but rather that the general approach on which the respondent places so much weight is subject to these small, we say, but well-established exceptions. Turning, if I may, then back to the ground one, and our submission that the brain tissue evidence in the case, in the trial, was fundamentally flawed. The concession, we say, at trial, made by trial counsel, following consultations with the experts he instructed, was flawed. The concession was perhaps understandable, but what he was directed by his experts was not. The respondents counter that submission by suggesting that, in fact, trial counsel had consulted 5 pathologists, and it was after that that he conceded the identity of the substance on the shirt. We don't accept that at all. It's not a numbers game, and as the respondents well know, Dr. Sinek, one of the 2 experts consulted by trial counsel, didn't even see the slides.
Dr. Venezis said he did. He looked at them.
He does, and I will address him in due course. Dr. Sinek, of course, was unaware of the unpreserved nature of the material that she was being invited to consider, and of course she didn't consider it in a sense of looking at the slides and simply relied on Dr. Miller's report. And so far as Professor Venezis was concerned, there is real concerns in this case over his expertise. He, of course, was a pathologist.
Sorry, concern over his expertise in what?
Can I explain? The evidence is that when trial counsel went to Dr. Venezis, he went to him asking him to undertake a number of tasks. One of them, the principal one, was to ask him about time of death. The second task related to the issue of how the tissue might have deposited, wet or dry. And the third was the identity of the tissue. Professor Venezis' reply was, I can advise you on time of death and the issue of how it was deposited, but you need to go and see a neuropathologist, Professor Graham, for the identity. So that was the plan. 20 days into the trial, trial counsel receives Professor Venezis' report, and it transpires that Professor Venezis didn't send the slide to Professor Graham, but looked at him himself. So, inferentially, there was, in the first instance, a concession by the pathologist that he didn't have the expertise, but in essence, he knew a man that did.
But which expertise? Professor Graham was a what?
Neuropathologist.
He was at a hospital in Glasgow, is that right?
Yes, that's
He was a
right.
diagnostic man, wasn't he? Isn't that what Professor Venezis said of him?
Yes.
If you want to match Professor Miller, you need a diagnostic man, because that's what Miller is.
Well, I'm not sure.
Have I got that wrong?
I'm not sure whether the email exchange didn't go that far, but that might be one interpretation.
Well, I may have got
didn't
it
go there. All it said was, for the identity of the cells, you need a specialist neuropathologist, and that was, he identified Professor Graham. So our submission is inferentially, here was Professor Venezis saying, you need a specialist to do the identity. Now, of course it's right that later Professor Venezis has told us in our email exchange that he indeed had the expertise, and that must be said. So we have two conflicting situations. But the point is, this was a major concession in the trial. Major. To concede it was brain tissue. And it seems to us that we're not being unduly critical if we raise an eyebrow and say, would reasonably competent trial counsel at least be concerned, having been put on notice that in the first instance Professor Venezis didn't think that he was the right man to go to, that all of a sudden he's on this very large issue receiving this information from him that he's had a look and that's what he saw.
Okay, can I ask you, when was the concession made at trial?
The concession was made according to trial counsel. He maintains in his response to the registrar that he relied on the report of Venezis. And if that's right, of course, it must have been after day 20 of the trial.
You've very helpfully set out the guts that you rely on from Professor Venezis' exchanges at skeleton 56
Yes.
onwards. Just for convenience, have you got the references for the raw material?
Yes, I
to
do.
hand?
Yes, I do. Can I just move forward in my speaking note and pick them up for you?
I'm sorry, if you're coming to it, Mr. Hislop, please come to it later, that's fine.
Right. Yes. Yes. The material in relation to the correspondence with Professor Venezis, my lord, is volume 7, and it is at tab 46, and it's 2822.
Thank you very much indeed.
And that is correspondence between us and Professor Venezis and
2822, is that?
yes.
Okay.
Yes.
Sorry, what does this correlate with in your skeleton? What paragraph?
Let me just.
56.
56 onwards.
Yes.
Thank you.
Yes.
But it doesn't, I think, help in locating the time of the concession.
No. We can only presume it must have been after day 20 of the trial.
But the sequence is Professor Venezis advised that presumably Professor Graham, be engaged. And there then seems to be something of a void. There's no contact between counsel and Professor Venezis as to why Professor Graham wasn't contacted.
No, none whatsoever. And we ourselves sought to get an answer to that from Professor Venezi, but all he could say was that he didn't give the slides to Professor Graham, and of course we have within the bundle of evidence that we have served referred to an affidavit of a Rowan Butler, who was then I think law clerk for trial counsel, and he was acting as a courier and delivered the tissue.
Yeah. Well, I think possibly your submission in this will be that if Mr. Behrens had the report form that's at page 319 of the supplementary bundle, and he saw that Dr. Teal had said that this was not, these slides could not provide the information, that would have made him A, all the more alert to the need to engage Professor Graham, and B, all the more astute about making a concession.
My Lord, precisely. Precisely.
As far as Professor Venezis is concerned, the email you've taken us to on page 2822 is one where he asserts that it is within his expertise.
Absolutely. That's why I hopefully very fairly put it. We have two conflicting situations. We have, on the first hand, the natural and reasonable inference to be drawn from his advices to trial counsel that he needs to have a neuropathologist, an expert in the name of Professor Graham. We say the natural and reasonable inference to be drawn from that is that Venezi didn't have that expertise, otherwise why bother? And then, of course, we have subsequently, to be fair, and as your Lordship quite properly stresses, Venezi comes back later and says, oh no, I am the man. I have the expertise.
So is the document which gives rise to the first of those, the one at 2851, it's an email of the 28th of August 2001. Is that where we find it, right at the bottom of the page? I have a specialist available, Dr. Who?
My Lord, yes.
So let's just see what it says as a whole. This email begins, there are a number of forensic issues in addition to the straightforward issue of whether the smear is brain or not. On the latter point, on the face of it, it looks fairly certain that we are dealing with brain tissues.
Yes.
This is before he's received the slide. This is simply preliminary correspondence discussing fees and legal aid and that sort of thing.
That's right.
Yeah.
That's it. He hasn't even looked at it, but
Yeah.
he has obviously.
But by the time he tells Mr. Behrens that he's pretty sure it is brain, he has seen the slides, has he?
Quite.
So he's doing it from appearance, as were Doctors Pang and Temple.
Yes.
Yeah?
From appearance. But
Microscopic appearance, of course.
no. Contrary, of course, to all, it seems, or every neuropathologist who has either then or shortly before it, Dr. Teo, and of course subsequently the two neuropathologists, Professors Whitwell and Dr. Wayne Squire.
At the top of page 2449, this is following through progress of the email as we get to the 6th of December, and it looks as though Mr. Butler is in Glasgow in possession of the slides.
Yes.
And the suggestion is he would go to Professor Graham, and we simply don't know whether that actually happened.
Well, we do now, because we've filed, and I hope it's before, and I'm sure it is before the court, an affidavit from the young man himself.
Oh.
And might I just look that up for a moment? Yes, our supplementary bundle, please. Tab 15.
Who's the deponent here?
The deponent is a my Lord 311, and at the bottom, and it is Rowan David Butler.
Rowan Butler.
Who is the person referred to in the email, isn't he? He's the person referred to in the email.
Absolutely,
Yeah.
absolutely. And he deposes, and we see it, that he travelled to Scotland, and at paragraph 10, he recalls delivering the slides to Professor Venisi at the Glasgow International Airport in December 2001. He makes an inquiry on the internet to identify a photograph of Professor Venisi, and he confirms in his affidavit that this gentleman was the gentleman indeed who he gave the tissue to. At paragraph 8 of the affidavit, he says, I have no recollection of dealing with a Professor Graham, and I did not deliver the slides to him. And then if we join up the dots, as it were, we know that Professor Venisi didn't instruct Professor Graham or give him the slides. It's our case, of course, that Professor Graham was never instructed. We have, of course, tried to seek the assistance of Professor Graham, but unfortunately he's not answering his emails, whether he's in the country or I don't know.
The email on page 2853, undated, this is the one, is it, that Mr. Barham sort of acted on at the trial?
Yes.
Yeah. And so it appears from that he's looked at the slides under the microscope with an H&E stain, and that's the basis of his conclusion.
Yeah. Yes. And as I say, we've made our point about whether or not, in fact, he was the right man. We have within the evidence that we invite the court to accept the affidavit of Professor Helen Whitwell. We find that at volume 6, tab 31, and if we might go to that, please.
I'm sorry, what was the reference?
Sorry, it's volume 6, and it's tab 31, and
What is this, please?
this is the affidavit of Professor Whitwell.
Yes.
And at tab 31, my lord, it should be
2505, yes.
Yes, 2505 at the bottom. And might we take the court, please, to firstly paragraph 5A. There, Professor Whitwell is describing the field of neuropathology. Neuropathology is a specialised area of histopathology dealing with disorders of the central nervous system. In particular, neuropathologists have expertise at the intraoperative diagnosis involving brain tissue. Neuropathologists are usually based within neuroscience units practicing in conjunction with neurosurgeons. It is not a speciality seen within the general hospital setting. Whilst forensic pathologists deal with cases of neurotrauma, most are not specialist neuropathologists. She goes on to make the point, indeed, that we have just made about the expertise of Professor Venices at paragraph 5b, and then goes on at the bottom of that page. I have personally viewed the slide from which Professor Venices purported to identify the material as brain tissue. So have Professor Gatter and Dr. Squire. We were all of the clear view that the slide contained no identifiable brain tissue. This was a smear preparation stained with H&E identification substances, and such slides is a difficult, identification of substances in such slides is a difficult and specialised task which requires specialised training. It should be performed by a neuropathologist. And one of the ironies in this case, insofar as the selection of experts is concerned, is that during the course of the trial, it would seem that trial counsel instructed Dr. Sinek. She, of course, was a neuropathologist, but one thing she wasn't asked to do was to identify or look at the tissues. Instead, she was asked to look at Dr. Miller's report and comment on IHC and the methodology of the procedure of IHC deployed by Dr. Miller. Ironically...
I think you said it moved on, hadn't it?
Yes.
Unless the neuropathologist could exclude brain tissue, the question was now whether Dr. Miller's different immunochemical processes were reliable or not.
That's right.
And none of the neuropathologists, including Dr. Whitwell, who is a neuropathologist, and various others, say that they can exclude it, do they? It all depends on whether the immunochemistry works or not, this case, doesn't it?
Well, not really, because if one looks carefully at the affidavit evidence of Professor Gatter and indeed Dr. Squire, what they say is what we see is consistent with brain tissue.
Yes.
But, and the but's the important thing, it could be any other animal tissue.
Yes, and therefore you can't exclude it. And therefore the question becomes, is Dr. Miller, who says he can exclude other things, right or not?
Well, and then we go the full circle and say to ourselves, well, was he looking at a substance that was degenerating? And if he was, he's the first man in the world to concede, I didn't have a control for that. And therefore it becomes an experiment, and the conclusions to be drawn from it are unreliable. So the great irony, as I say, of Dr. Sinek was she was a neuropathologist, but she was consulted and asked her opinion on something that she now says I was not an expert in. She was not an expert in IHC, and yet sadly she proffered an opinion that doubtless trial counsel relied upon. Professor Whitwell addresses Dr. Sinek's report at paragraphs 11. Yes, it's volume 5, and it's tab 13, please.
What is it we're looking at?
It is the first affidavit of Helen Whitwell.
Yeah, thank you.
And may I take the court, please, to her, to, as I say, paragraph 11 first. She says, my comments below should not be interpreted as criticisms of Dr. Sinek. I cannot comment on the circumstances in which Dr. Sinek received these instructions or what constraints she may have faced. However, in my opinion, Dr. Sinek was provided with insufficient material in order to reach the conclusions that she did. Further, I note that Dr. Sinek's instructions do not refer to the length of time the tissue had been present on the shirt before the sample was preserved. This is a crucial piece of piece of information which may have alerted Dr. Sinek to the need for more detailed investigations. Doubtless, she may have wanted to see the slides, but she never did. And she goes on to opine in 12 what Dr. Sinek might have been put on notice about in her.
What is she talking about in paragraph 13 about the highly selective photography?
Yes.
In the Miller report?
Yes.
Does she enlarge on that?
This is part of what Professor Professor Sherd and Professor Whitwell, they both looked at the report, and indeed Professor Gatter. They've all looked at his report, but they have had the benefit of looking at all the slides. Now, what Professor Sherd did, and we have been critical of him, but in light of what we now know from Professor Gatter, perhaps he might be forgiven. It seems diagnostically that a diagnostician like him would be well used to working where he would look at the very best examples of what he's setting out to prove insofar as the conclusions that he's come to as to the nature of the substance. And he did exactly that in his report. What he didn't do, and is criticised by Dr. Sherd and Professor Whitwell, and indeed Professor Gatter, is he didn't demonstrate, as Sherd's report demonstrates, that there were a large number of negative identification photographs. And so he presented one side of the picture, but not the other.
Why is it necessary to show the others if...
Well, I'm sorry.
Oh.
Well, it would not have been necessary in front of the jury because, of course, by then there was a concession as to the nature of the substance, and I accept that. But insofar as an expert is concerned, he has an obligation to set out his report in an impartial way. Now, in fact, the findings were mixed findings. There were a number of occasions in Dr. Sherd's evidence, we can see in his report, where there were unexpected results. Now, they weren't included in the report.
Were or weren't? They weren't.
Were not.
Well, your submission really results to this, does it? That he ought to have presented a more balanced picture. Instead, he chose the slides which most provided the most support for his thesis. Now, that's your submission. I think the contrary submission must be that once he had established, as he did to his satisfaction, that there were valid results in some of the slides, then the thesis was established, and it wasn't necessary for him to provide a spectrum of slides. It was merely sufficient to show the slides which most amply demonstrated his theory.
The difficulty with that in this case was that the negative results that he didn't show were not present to alert certainly others that might look at his report that there were two sides to it. And the two sides becomes an issue when the question is asked what impact there would be on the reliability of his findings if it transpired that the tissue was degenerated.
Yeah.
And Professor Sherd makes the point that you can't look at the positive results and say, well, it is brain tissue, and the negative results are artefact, when the converse could be the case. The artefact could be the real substance, and the positive could be the artefact. That's in effect what Sherd was saying.
But is there a double point then about Dr. Sinek's exercise? She, as you say, relied on what Dr. Miller said without examining the slides herself. That's point one. Point two, she didn't know that the material had been unpreserved for so long. That's point two. And point three, she wasn't aware of the less satisfactory material which Dr. Miller didn't reveal. I mean, and there's a difference perhaps between a pathologist having satisfied himself about the soundness of his thesis, presenting this in a report to show to the jury, and comparing notes with the expert for the defence who was asking to see the material and satisfy himself or herself whether there's a basis for challenge. And these are different exercises.
My Lord, it is. And we set out in our case, we refer to the case of Carter and the obligations upon an expert for those very reasons. And it's no answer to the selective process that went on insofar as Dr. Miller is concerned. It's no answer to say, well, the concession had been made because, of course, the concession hadn't been made when he made his report.
Now, are we now on the immunochemistry, which is a matter of chemical reactions?
Yes.
Or are we on the appearance of the cells on microscopic inspection? When you talk about the slides, it might be either, I think.
Yes.
Which is it? Which is it that the criticism of which the criticism is made,
right,
that Dr. Miller has been selective in his collection?
It is the IHC.
It's the IHC.
Because what the photographs depict is the staining.
The reaction.
The reaction of the antibodies.
Right. And is it your case that the slides which he didn't include positively demonstrate or positively suggest that the material is something other than brain, or are they equivocal?
They're not equivocal.
Right.
They're not equivocal. What happened was we had two types of antibodies to be applied to the substance. Mm-hmm. One, you get an expected positive.
That's it.
And I think there's three of them. And three of them, you get an expected negative.
Yes.
And insofar as what Sherd found was, there were negatives when there were meant to be positives, and there were positives when there were meant to be negatives.
When you would expect, yes.
And so nothing unequivocal about it. Sherd says one of the explanations, he thinks, is that you've got degenerative cells, and in due course, as I recall, figure 27 in his report, it shows a photograph of this, a degenerated cell, a cell where the nucleus was no longer there. He says that is typically a degenerated cell, and evidence of it. And the point he makes is there is no control in this experiment or rather this process, to put it in a neutral term.
What do you mean by control? You mean an undisputed sample of the lady's brain?
My Lord, the process is the unknown substance, a known antibody is applied to it.
Right.
And there is an expected result.
Yes.
And one tests the expected result on the slide with a control. So what happened was we have known brain tissue and the antibody applied to it, and we get a particular staining. Yeah. So we compare that with the antibody that we applied to the tissue. Mm-hmm. Now, if it's a true control, we have to test the control to make sure that it is the same as the tissue. In other words, it's gone through the same...
That the antibodies give the same reaction as they do with the questioned substance.
That's right.
Yes.
That's
well,
right.
Dr. Miller says, doesn't he, that he's done all that ages ago. He hasn't included it in his report. He says, this is the staple of my existence. I know which antibodies react to brain. That's what I do day in, day out, have done for years. That's his case.
Yeah, that's his case.
What is the control that you are saying he ought to have had?
Well, it was there was an impossibility. He was in the situation of not knowing what conditions that substance on the shirt had been kept in over many months.
So the criticism isn't of his methodology, it's of the fact that a forensic approach inevitably cannot have a controlled substance. Is that it? It
might follow, but I don't accept for one moment his methodology was right, because it can't be right because it's uncontrolled.
Well, I think my Lord is asking you, was it possible at the time that he conducted this examination to have a control?
No.
No.
Again,
well, then it's not so much that he didn't have a control as it was impossible for there to be a control, and therefore that's always going to be a shortcoming in
that's
the
right.
examination.
And Professor, and the evidence upon which we rely, being Sherd, Gatter, Whitwell and Squire, is that because of the nature of IHC, it requires very strict controls, and therefore without them the results are unreliable.
That amounts to a proposition. I mean, you may be right, I don't know, but it amounts to a proposition that you can never use immunochemistry in a forensic setting.
Well, that may well be.
Professor Whitwell says that, really, doesn't she?
Yes.
Right.
In theory, you could sort of, as it were, reconstruct something which was equivalent, deteriorated to the equivalent extent, but that's a very difficult thing to achieve, it is being suggested. In theory, you could do it, but in practice, no.
Probably highly difficult. Absolutely. The point that Sherd makes is this is the testing of an unknown substance with a protocol never before used. Dr. Miller conceded at trial, and he had never before applied the science of IHC to trying to ascertain the nature of a stain on fabric. It's something he had never done before, and he conceded that he doesn't think anyone else in the world had done it either.
Could you give a page reference to that? Do you have a...
Yes, can I...
it would be helpful to see how he puts it.
I will, if I may come back to that, I do have it.
Well, his affidavit is at 5:17, I think.
in cross-examination, I think you were suggesting.
Oh, sorry, in cross-examination.
I think so.
517. Did you say 5?
517, that's his affidavit.
5. Yes. Yeah. It'll be the...
Just while you're Junior's looking for that, could I understand what the burden of your submission on this point is? Do you say that Dr. Miller ought to have produced a report in which he said, well, I recognise that ideally one should have a control, but it's impossible to have a control, and therefore I put forward these results with the qualification that in the absence of a control there may be some doubt about their validity? Or do you say that because the need for a control was so fundamental to the reliability of the experiment that he ought not to have proffered the evidence at all?
The latter.
The latter.
The latter.
Does it matter to your case?
Well,
though?
it doesn't
Because-
matter. It doesn't matter which. My lady's right.
Yeah.
It doesn't matter which.
I mean, it does matter to your
I mean-
case, but you can put your case
Yes.
on both bases.
That's right.
Yes.
That's right. 7. I'm looking for mine. If I may. 7. Thanks, mate.
That is
Yes, just to try and identify where, in fact, Dr. Miller says that it hadn't been done before. May we take the court, please, to volume 7, tab 34, and in fact it comes. We find there the affidavit of Joseph Michael Jessup, and if we get to that tab, please, and go to page 2635 at the bottom. This is an article written by Dr. Miller, the Detective Sergeant Grantham, Bruce Lockett, Dr. Temple Camp, and Dr. Pang. And they're talking about this case, of course, and at 2635, the second column,
Yes.
third paragraph down, because we had no prior experience with processing shirt fabric, there was some concern that the shirt fabric would not adhere to the slide. I will, in due course, put my hands on that part of the cross-examination of Dr. Miller at trial, where he conceded as much.
Thank you very much.
Well, that's the fabric.
Yes.
And I
Yes.
absolutely see there's a point about the fabric
Yes.
and whether it interferes with the process.
Certainly.
But I mean, you're much more fundamental than that. Here is a matter of interest: is Dr. Miller writing up this particular case from a scientific point of view?
Yes.
Is it your case that this kind of immunochemical testing for the presence of one substance or another has never been used in forensic science?
Yes, yes. If we go forward in the article to page 2634, please.
Not widely used in the analysis of forensic evidence, under discussion.
Yes.
Right.
Yeah.
Was that?
This is the second column.
2634,
Halfway down
second
the
column,
second column.
under discussion.
Okay, right.
Yes. It goes on in 2635, the first column on that page, there's a reference to all the inquiries that the New Zealand Police had made of different laboratories around the world, trying to see whether they'd done anything like that. Right. And the negative replies from them.
Plus the evidence of the experts, the new evidence that you have,
Yes,
that in their opinion, at least the novelty of this should have been acknowledged.
My lady, yes, of course.
To rise because of course it's conceded. It's conceded.
At our paragraph 68, of course, we set out all in essence, complaints made by our experts about Miller's report. Professor Sherd, at our paragraph 70, reaches 11 conclusions as set out in his report. And if we could please go to volume 5, tab 12. And it's 1924 at the bottom.
Sorry, can you give the page number again?
1924 at the bottom.
Yeah.
It's tab 12.
Yes.
Now, is he a diagnostic expert in immunochemistry?
No.
No.
His professional qualifications are set out at paragraph 1 of his affidavit at 1905. He is an associate professor of physiology. And he states, paragraph 4.
Researcher.
Maybe I'll start at paragraph 3. I'm the author of 40 full research papers published in the international peer-reviewed scientific literature, as well as numerous books and chapters and 50 conferences, presentations. 4, I have been using immunohistochemistry as a principal research technique in my laboratory since 1990. I have extensive experience with immunohistochemistry and the light microscopy, with particular emphasis and interest in the use of the technique for examination of protein expressions patterns in the central and peripheral nervous system. His report at 1942 is set out, but can I make the point, my lord, insofar as a diagnostic is concerned? Professor Gatter,
He is a diagnostician.
he is indeed. And of course, we know that he, of course, has looked at the report of Professor Sherd and, in essence, adopts it and accepts it. And he, of course, now has also viewed the slides. And so what he and Professor Sherd agree is that, and this is at the bottom of 1924, it is my view that the results of the immunohistochemical procedure permit no reliable conclusion and that the previously presented photographic evidence had been collated to support a specific interpretation rather than to permit objective evaluation. I mentioned earlier in my submissions evidence that Professor Sherd was able in his report to demonstrate of a degenerative cell, and we can see that at 1940, page 1940, fig 27 of that report. A drop of blood is present on a negative control slide, not associated with the shirt. Blue dots represent the nuclei of white blood cells. Red cells appear as brown cells with no nucleus. And he explains that over the page and says that an absence of nucleus is symptomatic of severe tissue deterioration. And addressing that, if we go to 1943, and it is the second paragraph on that page, about 5 lines up from that end of that paragraph. In this case, we know the material was unfixed for an extended period of time, and the histological evidence is consistent with this, showing significant tissue degradation, since antibodies are designed to recognize proteins in their native functional configuration. It is very likely that the specificity of any antibody will be compromised if significant tissue degradation autolysis occurs. So that, of course, highlights the difficulty with degenerative tissue.
So that's the answer, is it, you say, to Dr. Miller's proposition? Got a lot, I know perfectly well which antibodies work. It's what I've been doing for years.
Yes.
It's the degeneration point.
Yes.
Right.
Yes, yes. And that's why at the very beginning, when the importance of Dr. Teo's observations, because of course they just happen now to have, we would say, a chilling resonance with the findings of Professor Sherd and the opinions of Professors Gatter, Whitwell and Dr. Squire.
There's a point in the second last paragraph on page 1943 which might just be worth noting.
Yes. My Lord, thank you. In short, the complete lack of knowledge of how the antibodies react on air-dried, unfixed tissue, the consistency and variability in antibody staining, the similarity in staining pattern between antibodies that should be dissimilar, and the lack of nerve specificity of the nerve-specific antibodies render reliable interpretation impossible. And that really sums up our case insofar as the evidence of Dr. Miller and more particularly the methodology that he deployed. Amongst the conclusions reached by Professor Sherd was, he concludes that the IHC procedure undertaken by Dr. Miller was an uncontrolled experiment that was incapable of producing a reliable outcome. We've made the point, and I don't think we need to further make them. At paragraph 71 and 72, of course, we address Professor Whitwell's endorsement of Professor Sherd's conclusions, as with Professor Gatter. Paragraph 25, it's our submission.
75 or 25?
Sorry, 75 of the appellant's case, my Lord. stress there the importance of the distinction between cases of expert shopping post-conviction and cases of bad science. This, we say, is in fact the latter. Of course, the former is to be deprecated, but we say this case is an example of the latter. This isn't a case where the appellant held back evidence that he could have called for tactical reasons, but rather one which the prosecution, where the prosecution led novel scientific evidence. We say that was presented in a misleading fashion, and we say it doesn't sit, and we pray and aid, of course, the case of Oliver. Yet, notwithstanding that this evidence might have been available at trial, we say it is in the interests of justice to admit it, and if it is so admitted, we say it makes a difference and would have made a difference. Trial counsel relied on his experts in concluding that he should not seek to contradict Dr. Miller's report. While, as we say, this was understandable, at the very least one would have raised an eyebrow, especially if he was armed with Dr. Teo's opinion. Raised an eyebrow with Professor Venisi's report, bearing in mind Venisi said that he needed a neuropathologist to identify it in the first instance. My Lords, I made reference earlier to the case of Carter. And we see that at paragraph 79. We draw the court's attention to that, and in particular subparagraphs E and F. The expert must not give opinion, evidence outside his or her area of expertise. F, if an expert witness believes that his or her evidence might be incomplete or inaccurate without some qualification, that qualification must be stated. And I think that might answer your Lordship's question earlier, whether Miller had a duty, in fact, to present the whole picture and not that picture that purely proved his diagnoses. One imagines, and one's not now that critical of Miller, because it's clear that he is a diagnostic clinician. He wasn't a forensic expert, so he would not know, presumably. I don't know. I'm guessing, but it doesn't appear that he was a man used to forensic opinion.
And does it follow that you really have to say, and you are saying, that nobody on the defence side would have had any idea that this was completely novel, forensically?
No.
Well, really?
Well, no, certainly they did know, because Dr. Sinek, in correspondence with trial counsel, remarked that she had never seen anything of this nature before. She went on to say, in fact, it was an email exchange between trial counsel and Sinek about fees. And trial counsel was saying, well, look, can you do it for nothing? And because Dr. Miller is, and the response from Dr. Sinek was, well, look, I've asked my colleagues, this has never ever been done before, and an expert would probably give his right arm to do it, because it's so novel.
So whilst you're obviously right that part of the expert's duty is to say, if it's novel, this is novel, that was in fact well understood.
Well, it certainly was understood by trial counsel and
his experts.
And Dr. Sinek.
Yeah. So then it's a question not so much of not disclosing the novelty as whether it is in fact reliable.
Yes, quite. We would say the fact that it was novel gives greater concern.
But is there any evidence that Dr. Miller believed that his evidence might be incomplete or inaccurate? What you are saying ex post facto is that it can be demonstrated to be incomplete or inaccurate. But the injunction in the passage to which you have taken us is if an expert witness believes that his evidence is inaccurate.
I think what we stress is without qualification. If a forensic expert sets out his conclusions and reasons and in it doesn't qualify the fact that that some of his tests in fact prove the contrary to his proposition, then only part of the picture is being shown. And with respect, I think that certainly would be our interpretation of subparagraph F.
So it's a selective photograph.
Yes, and I think my Lord made the point earlier, not infrequently, especially these days, and courts encourage it, experts get together to discuss propositions and agree reports. And if one side is not showing their full hand, then justice is not going to be done by any joint report. It's going to be fallible because only part of the hand has been shown. That's the point. Might I take the court, please, to the transcripts of the evidence, and it's at page 861, and I will just identify it, please. It is in our bundle, volume 2, and it's 861 at the bottom. No, sorry.
Are you looking for a passage in Miller's evidence?
My Lord, yes, no,
Your 861 in the original is...
Oh, I see what's
984.
I see what has happened here. If I could take it forward in the bundle, please.
984 is what was 861.
Is that volume 3?
Yeah, and it is volume 3. Thank you, my lady.
964.
Down, please, and it's 984 at the bottom. Thank you, my lady. And it is line 21. Dr. Miller. Dr. Miller is being asked, and as well as that shirt, 2 envelopes containing samples already taken from the shirt by the ESR. Yes. Now, in your work, Dr. Miller, had you been asked to analyse tissue that appeared to be on or in the fabric of an item of clothing? No.
But the only difficulty he had was actually in mounting it on the slide. Is that what you're saying? Whether you'd be able to cut it and mount it and have it adhered.
Yes.
It doesn't look as though it has anything to do on the interpretation of the results.
No. No. Okay.
I wonder whether that's a convenient point to
Yes.
break. Our clock here is just a little bit slow.
Yes.
How are you getting on? We've been covering a lot of detail this morning.
We have taken some time, but I will endeavour over the luncheon to pick up the pace.
Yes, I'm not trying to rush you, it's just simply for information. I mean, you
No, we are going slowly. Ground 1 and 2, or 1 and 3 require a detailed analysis. 2 and the rest
Yes.
can be taken fairly shortly.
Yes. Good. Well, we look forward to seeing you at 2 o'clock.
We've got